can.
That's Miss Cheryl.
exactly what it is.
She's here.
Yeah, it's nothing like substantive. I think it's just like a status.
I was just saying, that's Miss Cheryl. She's here on Zoom.
Oh, maybe call that once it's done. All right. Bye. Everyone's there?
How's it going today?
Oh, it's going, man. Dickerson in the back too?
Dickerson's back here.
Oh, I can't talk right now. Well, I'm in the middle of work, so I can't. Yes. Yep. No, I. Okay, good.
That's where I usually sit. I stay in my 20s.
Judge, I got the fifth floor today for council. I swapped with Mercier. He's out of town. I sent David Dawn an email. So
Okay.
you guys, yeah, here, I'll give you a card real fast. He's got my cell phone. Just call me. I'll come
Thank you.
around it. All right.
Thanks.
Today. It's all there.
Ready to Taylor?
Taylor ready.
Ready, Your Honor.
Calling case number 19-6885-01-FH, People State of Michigan versus Michael Taylor. Appearances, please.
Good morning, Your Honor. Sean Callahan on behalf of the Probation Department.
Bob Zaranick for Mr. Taylor, Your Honor, P 39346.
solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name for the record and spell it.
Michael Taylor, MICHAEL
And you, we're handling this matter on Zoom today. Are you okay with handling this matter on Zoom?
Yes.
Okay, go ahead, Ms. Callahan.
Your Honor, today's the date and time set for a probation violation hearing. We're tracking a matter in the 46th Circuit Court where a competency exam was ordered. As far as I know, there is no next court date in the circuit court. I'm not sure if Mr. Taylor's been notified of a next court date or not.
No.
I would just ask that this matter be set out about 3 weeks. I know we've been waiting a long time, but I'm not sure what else to do.
Okay, Mr. Zaranek, anything you want to add?
I don't have any update either, Judge, so I'm in the same boat. I'm thinking that would be the best idea is to put it out a ways.
Okay, we'll set it for March 17th.
Okay.
Thank you.
Thank you.
Mr. Taylor, have they even interviewed you yet? Has the Forensic Center even interviewed you?
Yeah, I got interviewed already.
Okay, hopefully we'll have a report then in a month.
Judge,
Okay.
I just want to add that Mr. Taylor has been reporting. Things have been very calm. He's living with his mom, so he's doing well on bond.
All right, very good. All right. See you on the 17th. Thank you.
Thank you.
Thank you.
Thanks, everybody. Have a good weekend.
You too.
Thanks.
Ready at Jackson?
Not quite ready on Axon, Judge. Pass that for a second.
How about Cheryl?
Adam.
Okay. Calling case number 22-6025-01-FH, People State of Michigan versus Crystal Cheryl. Appearances, please.
Andrew Mulder on behalf of the people, P83773.
Morning, Judge, you and your staff, Cody Bradford with NDS Detroit P85944, on behalf of Ms. Cheryl, who is present via Zoom and consents to Zoom today.
And Ms. Cheryl, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? You have to unmute yourself.
Yes,
Please state your name for the record and spell it.
Crystal Michelle Sherrill, Crystal Michellerell.
We're handling this matter on Zoom today. You have any objection to handling this matter on Zoom?
No,
Okay, so we're here today for a decision regarding defendant's motion to suppress the identification. You can be seated. On February 21st, 2023, this court conducted a hearing regarding defendant's motion to suppress identification. At that hearing, the complaining witness, Candace Thomas, testified that on June 12th, 2019, she was at Madison Carver Academy between 7:30 and 8 a.m. to drop off her 3 children. However, during that time period, a car pulled up next to her, argued with her, and pulled a black handgun on her. Ms. Thomas testified the defendant was driving a tan 4-door Dodge that was about 2 feet away during the time of the incident. She described the other party as a heavy-set African-American female who she had previously never encountered. Ms. Thomas indicated that the entire incident lasted approximately 5 minutes. She further indicated that she memorized the license plate of that vehicle driven by the defendant. After the incident, Ms. Thomas reported the incident to the school resource officer and went to the precinct on Grand River and McNichols the same day. She was advised that the police would be in touch with her. On June 28, 2019, Ms. Thomas returned to the police station. At that time, there was a lineup of 6 photos. she testified that she identified defendant in 1 to 2 minutes and was certain of the identification. Ms. Thomas stated that the defendant's eyes were a key feature and that they were larger than average. Cross-examination, Ms. Thomas indicated that she advised that the person involved in the incident was an African-American female. She admitted that she made her statement not on June 12th, but on June 13th, 2019. In other words, the day after the incident rather than the same day. Ms. Thomas indicated that the photos in the lineup were in color and that the defendant had the lightest complexion of all the women in the lineup. On redirect examination, Ms. Thomas testified that the police officer who provided her with the lineup did not suggest anyone to her, that the differences in complexion among the individuals in the lineup did not influence her identification. The hearing was adjourned to February 24th, 2023, because Detective Austin did not appear. On February 24th, 2023, Alan Austin, detective of the Detroit Police Department, testified that he served as a police detective for 10 years, while as a police officer for 23 years. Detective Austin stated that he spoke with Candace Thomas, took a statement from her, and provided Ms. Thomas with a photo lineup. He indicated that the defendant's photo was identified after Ms. Thomas provided the license plate of the car. Detective Thomas determined from the license plate number given to him that the defendant was the owner of the car. He testified that he selected the other photos in the lineup and advised Ms. Thomas that the person she is accusing may or may not be in the lineup. According to Detective Austin, Ms. Thomas instantly identified the defendant. He indicated that he did not suggest anyone to Ms. Thomas. Additionally, he did not record the lineup procedure and explained that while some officers record it, it is not required. He admitted that the police report that Candace Thomas's statement did not contain a description of the person involved in the incident. Detective Thomas agreed that 4 of the 6 photos in the lineup are females who have darker complexion than the defendant. As set forth in People versus Henry after remand 305, Mischief 127, 116, and 161, 2014 case, the photographic identification procedural lineup violates due process guarantees when it is so impermissibly suggested that it gives rise to substantial likelihood of misidentification. Quoting People versus McDade, 301 Mischief 343, 357, 2013 case. The suggestiveness of a photographic lineup must be examined in the light of the totality of the circumstances. As a general rule, physical differences between the suspect and other lineup participants do not in and of themselves constitute impermissible suggestiveness. Differences among participants in a lineup are significant only to the extent they are apparent to witness and substantially distinguish defendant from the other participants in the lineup. It is then that there exists a substantial likelihood the differences among lineup participants rather than the recognition of the defendant was the basis of the witness's identification. In the motion to suppress the identification, the defendant asserts that the identification procedure with the complainant was unduly suggestive because it was not a double-blind lineup. However, the defendant has not cited any law that requires a photo lineup to be double-blind lineup. And it contends that the procedure violated DPD policies because Ms. Thomas was interviewed by Detective Austin the day after the incident, at which time Ms. Thomas gave a statement. However, Detective Austin did not conduct a photo lineup until 16 days later on June 28, 2019. However, defendant does not introduce and cite any DPD policy that she claims was violated. It does not cite any law which provides that the lineup must be done at the time Detective Austin took the statement, or that there was some inappropriate conduct during the period of 16 days, which made the lineup unduly suggestive or a ruse. It's also alleged that the defendant also argues that the procedure was unduly suggestive because the defendant was the only African-American female with light skin shown in the photo, and it was not sequential. Defendant cites no law or policy which provides that a photo identification must be sequential. Additionally, while individuals in photographs 1, 3, and 6 have dark complexions, the person in photograph number 6 has a substantially similar skin tone as the defendant, and the person in photograph number 5 has a medium dark complexion. Furthermore, while individuals in photographs 1, 3, 4, and 5 are smiling, the defendant and the person in photograph 6 are not smiling. There are also similarities. All of the females in the lineup have long dark hair, appear to be the same age, and present with similar facial features. The procedure, it's argued again that the defendant argues that the procedure was unduly suggestive because Detective Austin neglected to give the complainant previewing instructions informing her that the perpetrator may or may not be in the array. This allegation is not supported by the testimony. Detective Austin testified that the person she is accusing may or may not be in the lineup. And finally, the defendant argued that the procedure was not video or audio recorded. In fact, Detective Austin did not create a written record documenting the words exchanged between himself and Ms. Thomas before, during, or after the lineup. Again, defendant cites no law or policy that requires photo lineups to be recorded or set forth in any written record. Again, in that the photographs, I think, have enough similarities, and because the arguments raised by the defense have largely been unsubstantiated, and because I don't think the differences in the lineup are suggestive or create I don't think they're so different that they're impermissibly suggestive to call into question the lineup. And for the other reasons stated on the record, the motion to suppress is denied. Understanding that, how do you want to proceed, Mr. Bradford?
Judge, we would like to have, to this date, we haven't got the transcript from when Ms. Candace Thomas testified. We also need the transcript from the officer who testified last week. I don't think there's enough time to get that transcript before trial and actually look through it for trial scheduled on the 6th. So I'd ask trial to be moved.
I'm not going to turn the trial. We'll try to expedite the transcript. But at this point, trials are very scarce. I think try to accommodate
Judge, respectfully, if we have trial on the 6th, it's likely that the appellate defense, the appellate level is going to deal with this case, and it's likely to have a new trial after this. I don't think we're going to have time to prepare. And I know Your Honor would like to have justice, and justice delayed is justice denied. I get that, but at the same time, we had Ms. Roett's Ward leave the office. I just got this case. I barely had time to even get to know Ms. Cheryl, and because of that, and we don't have the transcripts. It's under oath. We need the transcripts, and I can't have it the day of trial or right before trial. I actually need time to prep for the trial.
well, we just handled this testimony. It's not as if there's any of this that's really surprising or unknown. You've been handling this case for about 30 days or more.
Maybe 2 or 3 weeks, Judge.
Okay. Well,
respectfully, again, if we do this trial on the 6th, it's likely that the appellate level is going to deal with this. And I know you don't.
what makes you think that somehow this is going to be create a record on appeal?
Because I don't have time to prep for it, Judge. I just got this case.
Well, I mean, the issues with your office are your issues.
Well, if it would have been a different office, it wouldn't have mattered. We can't handle when somebody leaves our office. Their cases have to be redistributed to attorneys, Judge.
Well, this is not a complicated case, and this isn't a murder case with a lot of experts. I think there's plenty of time. I mean, this case is gonna be what, 2 days?
I assume so, Judge.
Okay. And you've got
A trial next week and multiple exams at the end of next week that will not allow me to prepare for the trial that is the following week.
No, I'm not.
Okay, just for the record, the word defense objection. Thank you.
I understand. All right. See you on the 6th. Ready on action. Ready. Calling case number 22-7268-01-FH, People State of Michigan versus Jonathan Axon. Appearances, please.
Andrew Mullen on behalf of the people, P8377.
Good morning, Your Honor, Neighborhood Defender Services of Detroit by Natalie. P83355 appeared on behalf of Mr. Jonathan Axon, who's also present in the courtroom. Mr. Axon, can you please state your name for the record?
Yes, good morning, Judge. My name is Jonathan Brooks.
Axon, Ms. Phelps, and Mr. Molnar. Today's the date set for a hearing on the motion to quash. Go ahead, Ms. Phelps. Keep in mind, I have read the full transcripts.
Okay, thank you, Judge. And I imagine you had an opportunity to review my motion as well.
Yes.
I'm sorry. You didn't say-
No.
Okay, Judge, thank you. Your Honor, I think that I'll mainly rely on my written motion here, but I think that this case really boils down to 2 points that I made in the motion. So as I'm sure you've seen, Mr. Axon is charged with 4 counts at this point after the preliminary exam. The first being OWI causing serious injury as to a Mr. Kellen Favor, and the same charge as to a Miss Not, and then counts 3 and 4 are reckless driving causing serious injury as well to the same 2 individuals. And Your Honor, I think that the district court here really abused its discretion when it found over on this case. At the preliminary exam, there just wasn't enough evidence presented on the record to establish probable cause for all of the counts. My motion focuses on counts 2, 3, and 4. So the only count that it's not focusing on is the first count, that is the OWI causing serious injury as to Mr. Favor. So then the other 2 points, or excuse me, Judge, the other 3 counts are covered by the 2 points that I make. That number 1, there wasn't enough evidence presented at the prelim to establish probable cause that Antoinette Not suffered serious impairment of a bodily function, and that element is necessary for both counts. Excuse me, I think it's actually count 1 that pertains to her. Yes, for both counts 1 and 3, both the OWI causing serious impairment of a body function and reckless driving causing serious impairment of a body function both contain the element that there had to have been evidence of an injury causing serious impairment of a body function. And at the prelim, I'm sorry, but that wasn't okay. At the prelim, Ms. Knott did not testify. The only testimony that was on the record, the only evidence that was presented as of her injuries were from Mr. Favor, her partner, and that his observations were that she was limping after the accident and that she was in a boot. Nothing more was put on the record.
Wasn't there some testimony that she was in a cast, in a boot, and she was limping? There was also testimony, correct me if I'm wrong, that after the accident, she couldn't do any chores around the house. The family members had to help out.
Yes, Judge. The cast, I don't recall that there was evidence of a cast in the preliminary exam transcript.
It's on
Um,
page 21.
Page 21, and that is of volume 2, correct? Volume 1, yeah. You said page 21.
Yes. Line 20, she was in the cast, yes.
Oh, right, okay. So Judge, the case law that I attached to my brief, I know that the Court of Appeals unpublished cases are now binding on this court, but I think that they really illustrate the kinds of injuries that rise to the level that would satisfy MCL 257.58C. So I attached quite a few cases, but as you can see in my written motion, all of those cases involve some evidence of, a bone break and an inability to work, an inability to actually use the limb. And in this case, the evidence that we have is that she was in a boot, that she was limping. But Your Honor, I don't think that that's enough evidence to show that she couldn't actually use the limb during whatever period it was. It wasn't even established how long that was. Your Honor, so as to Ms. Knott's injuries, again, I would assert that there just wasn't enough presented at the preliminary exam. If she come and testified, if medical records had been submitted, which, could easily have been done at the preliminary exam using different hearsay court rules, but that wasn't done here. And I think that, we have these procedures of the preliminary exam for a reason. Like they have to be followed in order to, preserve justice, right? So, Your Honor, if we start saying that, just a little bit is enough to establish this kind of a serious case, then where does it stop? It's a slippery slope. There has to be a cutoff point. And in this case, there certainly wasn't enough presented at the preliminary exam to establish that her injuries, again, are serious enough to rise to this level. So that is for the series of the injuries argument. And then the other issue in this case of the prelim is the reckless driving charge. They didn't present any evidence of driving at all. I mean, they presented evidence that there was a car accident and there was testimony of statements made by Mr. Axon that he was the driver of his vehicle, but as to anything else about the driving, absolutely nothing was established. Mr. Faber testified that he didn't see anything. He was in the car and he felt a crash. That's the only testimony that we have about the crash at all, Your Honor. And as I stated in my written motion, there are cases that where OWI causing injury and reckless driving causing injury are both, there was enough evidence for conviction of those. And in those cases, there's always evidence of the reckless driving. Here, just saying that there was an OWI is not enough to establish the elements of reckless driving. And again, I think that the case law that I submitted supports that, including the cases showing that there is no double jeopardy issue when convicted on both counts, because there is additional elements of reckless driving that have to be established. That is the actual reckless driving. Again, absolutely nothing was presented at the prelim as to the recklessness of the driving, Your Honor. So I would ask that counts 1, 3, and 4 be dismissed.
Mr. Woolman?
Judge, in lieu of repeating what you had already stated about the injuries, I will just add the fact that, this preliminary exam took place in November of last year, when the crash took place over a year earlier than that. And Mr. Favors testified that his wife still has back issues and leg problems, which I think at least creates a question of fact for a trier of fact, that the injury caused serious impairment when a full year and a half later, she's still dealing with the effects of the injury. In terms of the reckless driving, or I guess I'll talk about first the fact that, Mr. Axon was driving the car, at all. And that's the fact that there were 2 vehicles that were clearly involved in an accident when police got on scene. he admitted to being one of the drivers of the vehicle. And there was testimony from Mr. Favor that when his wife was operating the vehicle, they had a green light and he saw the other car approaching. He has a green light that at least should establish probable cause that, or at least a question of fact.
Where was that in the transcript? Just so
I see it when the court is talking about why they bound it over, but that page. I think it's on the earlier transcript. Okay, it is on the first transcripts, the shorter one, the 30-page one, on page 13.
You point to a line where it says the light was green?
I don't see him saying that it was green, so I guess I don't know where the court got that exactly. But he does state that they're approaching the light when the other car kind of comes out of nowhere and hits them on the side. I think in terms of a question of fact for a trier fact, I don't think that the judge abused their discretion. And I think that, a jury with more testimony could find that reckless driving did occur. So I think just the circumstantial evidence, all the testimony together, I don't think based on that the court abused their discretion.
And if I could just briefly respond to that, just to the circumstantial evidence portion of Mr. Molnar's comments. Of course, the court is allowed to draw reasonable inferences, but in this case, those inferences have to be based on facts and evidence. And here, for the reckless driving, there were no facts in evidence about the actual driving. Again, page 13, it says they were approaching the light. And that, again.
Well, let's assume they're approaching the light. They're not even at the light.
Right.
And then all of a sudden, they're struck by another vehicle. Isn't that evidence that somebody was arguably being reckless when they struck them?
No, Judge.
Even without
Accidents
any.
happen all the time.
Well, we're not talking about a fender bender. We're talking about a crash where cars had to be towed away.
Your Honor, again, accidents happen all the time. There has to be something in evidence about the driving, about the cause of the accident. There was nothing here. You can't just make assumptions based on facts that are not in evidence. And there has to be at least a low level of information presented by the government at the prelim about the recklessness of the driving. And there just wasn't here. Mr. Favor said that he was laying back in the seat and couldn't see. He didn't see what the car looked like. He didn't see where they came from. He didn't see anything. We don't know. Someone's brakes we don't know. We don't know what caused the accident.
And Judge, I would agree with that. We don't know, and that's why the standard is creating a question of fact for a trial of facts. And you know, it is true that it could have been something else, but that's the kind of thing that's decided by a jury at trial.
Your Honor, the standard is probable cause. And there has to be evidence of each and every element of the charge presented at the preliminary exam, even if it's circumstantial evidence. That wasn't presented here.
All right, well, I'm gonna make a partial ruling today as relates to Ms. Nod and the serious impairment of the bodily function. I do think there was enough probable cause to establish a serious impairment of the bodily function, at least to a probable cause standard. There was testimony that Ms. Nod had no injuries prior to the accident, that after the accident, she was in a cast and a boot. That after the accident, she could not do any chores around the house. Family members had to help. And that even at the time of the preliminary exam, she was still suffering from the effects of the injury. So I do think there was sufficient probable cause as to that, as it relates to motion to quash. With regard to the reckless driving, I'm gonna hold any decision at this point, review the transcript of the case law a little bit more. And let's see, we don't have a next date, do we?
Your Honor, I think that we have a jury trial scheduled.
We have a jury trial on April 17th.
Okay, good. I'll have a decision for you by March 17th.
And Your Honor, when you say decision, do you want us to come back to hear it?
Yeah, I said, let's have an in-person hearing. I may issue a written decision. Either way, it'll give you a chance to sort of maybe even pre-try this case, depending on how the answer is prior to the trial.
Your Honor, could I just request that Mr. Axon be able to appear via Zoom? I know you just had in person, but he does travel an hour away to get here. He lives in Inkster.
He lives in Inkster? That's not a problem.
The address, so I set up the ride for him and it does take 45 minutes to an hour to get here from there. It must be the western edge of.
Yeah, no, I don't live terribly far from Inkster. I know exactly where it is. I think in terms of the types of best in person. See you on the 17th in person. Thanks.
Is that are both of them? Yeah. It's just not that. Gotcha, okay. Could I copy that? Do we need to redo that or just cross out? These are from January.
No, I think that's. Yeah.
Gotcha, okay, we're just looking for a diversion order that was sent.
I mean, you can.
It's not urgent, I was just making sure we had it.
I think I just need to sign it.
Okay. Are we gonna go on the record with it or? Mr. Folsom.
Sure. All right, let's do it right now.
Okay.
Well, I would think it's, right.
Yeah, probably.
Yeah, but I'm just, I don't know.
Then probably.
Oh,
You were like clear.
I wonder-
30. Like 30. So I'll be there. I'll come down.
Yeah, we do have a travel agent.
Is Eric Polson?
Yes.
Calling case number 22-7458-01-FH, People State of Michigan versus Eric Polson. Appearances, please.
Andrew Golden on behalf of the people, P 83773.
Good morning, Neighborhood Defender Service by Kate Demott Grady, P 83667, on behalf of Mr. Eric Olson, who is with us in the courtroom. Mr. Olson, please state your name.
Good morning, Mr. Polson, Mr. Grady, and Mr. Molnar. So it looks like we have a diversion order here. I think obviously, Mr. Molnar, you have no objection to the motion to place Mr. Polson on diversion. Mr. Polson, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Please state your name for the record and spell it.
Eric Folsom, ERICPOLZIN.
All right. Can you read, write, and understand the English language?
Yes.
Make your hand up. You understand if you're placed on diversion, you have to abide by all the terms and conditions of diversion. And you understand that if for some reason you don't do that, the diversion is going to be revoked and you'll be in front of me for a pretrial. Do you understand that? Yes. I'll sign you.
Thank you, Your Honor.
Okay.
And that review date is that February 24th, 2024?
Yeah, February 23rd, 2024. Correct.
Perfect, thank you.
I have to electronically sign this, which means it takes longer than if I just use a pen. So
I know that battle. well.
there's the magic of getting this to my clerk, who then does her voodoo or whatever she does, which is beyond my pay grade. But I signed the word.
Perfect, thank you.
All right, have a nice weekend, everybody.
You as well.
We're ready on firm, I think.
Yes.
Which one?
He's in the back. there.
Okay. Oh, did you say this is Lavon? Is that?
Yeah.
Oh, okay. Calling case number 22-6748-01-FH, case number 22-3674-01-FH, case number 20-3936-01-FH, People State of Michigan versus Lavon Kern. Appearances, please.
Good morning, Your Honor. Jacob Bloomers, P 77307, on behalf of the people on the case ending 6748. And good morning, Your Honor. Andrew, on behalf of the people on the case ending in 3674.
Good morning. Lita Barrett on behalf of Levon Hearn, P 43238.
Hearn, Ms. Barrett, Mr. Bloomers, and Mr. Mullen. So today's the date set for a pre-trial. Looks like we have some resolutions. Mulder, since you're standing, you can go first.
That's correct, Judge, and I was gonna ask first because if this court remembers, we did have a resolution before, and we were not able to meet the factual basis on the 3674 case, so I'm gonna try that one first.
Okay.
In our case, Mr. Hearn would plead to count one felonious assault, which carries a statutory maximum penalty of 4 years, and count three felony firearm, which carries a statutory maximum and mandatory sentence of 2 years. The people would agree to dismiss counts 2 and 4. And there would be a sentence agreement of 1 to 4 years of the MDOC on count one and 2 years MDOC on count three to run consecutively. Any other terms and conditions set by the court.
And then you're out of the offer on the file ending 6748 would be to plead to count 2, assault with intent to do great bodily harm less than murder or by strangulation. That is a 10-year felony. The people would agree to dismiss counts 1, 3, and 4. The parties would agree to a sentence of 1 to 10 years MDOC to be served concurrent with the sentence on 3674. Batters counseling, no contact with the complaining witness, any other terms and conditions set by the court.
Full of understanding, Ms. Barrett?
Yes, Judge.
Okay. Mr. Hearn, please stand and raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, please state your name for the record and spell it.
Levon Hearn, LEVAUGHN,
All right, can you read, write, and understand the English language?
Yes.
Sir, you'll be asked a series of questions. If at some point you can't hear, you don't understand something someone says, please interrupt and let us know. And then we'll stop and go over it again to make sure that you do hear and you do understand, okay? And if you're asked a question, if you give an answer, I'm gonna assume that you understood the question, and the answer that you gave was the answer you intended to give. Fair enough?
Yes.
All right, have you heard and understood everything so far?
Yes.
How old are you, sir?
22.
And how far have you gone in school?
11th grade.
Are you a United States citizen?
Yes.
Holding in my hands forms entitled Settlement Offer, Advice of Rights, Notice of Acceptance, and they contain the plea and sentence agreements that were just placed on the record. Have you seen these forms before?
Yes.
And did you review these forms and their contents fully with your attorney, Ms. Barrett?
Yes.
Did she explain each plea and sentence agreement to you?
Yes.
Did she answer all of your questions?
Yes.
Did she explain to you the rights that you're giving up by pleading guilty?
Yes.
And did you sign each of these forms?
Yes.
Did anybody force you to do that?
No.
Did anybody promise you anything other than that which is contained in these forms?
No.
Do you understand, with regard to case number 22-3674-01-FH, you face a statutory maximum penalty of 2 years on the felonious assault charge, and then up to 4 years, 2 years on the felony firearm count. You have to serve mandatory, and then up to 4 years on the felonious assault count. Do you understand that?
Yes.
And if you were to proceed to trial and were found guilty as charged in that case, what would be the statutory maximum penalty?
That would be 4 years on counts 1 and 2, and 2 years mandatory on counts 3 and 4.
You understand that, Mr. Hearn?
Yes.
And then as it relates to case number 22-6748-01-FH, you understand you face a statutory maximum penalty with this plea of 10 years in prison.
Yes. Your Honor, I'll wait to plea. I didn't.
Okay.
I know you're
Right. And you understand if you proceeded to trial and you're found guilty as charged, it would be up to 10 years in prison.
Actually, that if convicted on count 1 unlawful imprisonment, it would be 15 years maximum.
Was there an enhancement?
No, Your Honor. So defendant is pleading to count 2, the GBH in this case, but count 1 unlawful imprisonment is a 15-year felony.
Okay. Thank you for that clarification. Do you understand that, Mr. Hearn?
Yes.
And again, if he was convicted of a felony firearm, that would have been just concurrent anyways. Right, Mr. Bloomers?
Yes, Your
Do you understand that, Mr. Hearn?
Honor.
Are you satisfied with Ms. Barrett's representation of you?
Yes.
You understand you have the right to a jury trial, which 12 impartial jurors would decide whether you're guilty or not guilty of any crime charged.
Yes.
You understand you can give up your right to a jury trial and allow me to sit as the fact finder and determine whether you're guilty or not guilty of any crime charged.
Yes.
You understand you have the right to be presumed innocent until proven guilty.
Yes.
You understand you have the right to have the prosecutor prove you're guilty beyond a reasonable doubt.
Yes.
You understand you have the right to have witnesses against you appear at trial to testify.
Yes.
You understand you have the right to question or cross-examine those witnesses through your attorney, Ms. Barrett.
Yes.
You understand you have the right to call your own witnesses to court.
Yes.
You understand you have the right to have the court subpoena or summon witnesses on your behalf, requiring them to appear.
Yes.
You understand you have the right to remain silent at the trial, and you cannot be compelled to testify.
Yes.
You understand you have the right to not have that silence used against you. So in other words, if you decided to proceed to trial and not testify, I would instruct the jury that they couldn't have held that silence against you.
Yes.
You understand you have the right to testify on your own behalf if you so choose at a trial and tell your version of the facts. You understand that by pleading guilty, you're giving up all the rights that we've just reviewed.
Yes.
Other than the plea agreement and sentence agreement that have been placed on, each sentence agreement that have been placed on the record, does anyone promise you that you plead guilty?
No.
Does anyone threaten you, coerce you in any way, force you to plead guilty?
No.
You understand that if I accept your plea, I'll be giving up any claim that your plea was a result of a promise or a threat unless you tell me about it right now.
Yes.
Are you pleading guilty voluntarily in each case and of your own free will?
Yes.
And you're currently on probation, correct?
Yes.
And that's in front of me.
Yes.
And do you have any other probation cases other than the one you're in front of me? And you understand that by pleading guilty in these cases, that would constitute a violation of your probation in the other case that's in front of me. It could result in further consequences. And you still wish to proceed?
Yes.
You understand that by pleading guilty, you're giving up your right to appeal your guilty plea as a right, and even though the Court of Appeals may grant you leave to appeal, that's by no means obligated to do so. You understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes.
And to Mr. Bloomers, Mr. Molnar, and Ms. Barrett, are any of you aware of any promises, threats, or inducements other than those already disclosed on the record?
No, Your Honor. No, Your Honor.
No, Judge.
All right, I guess, Mr. Molnar, would you please clear the factual basis?
Yes, Judge. Mr. Hearn, on April 23rd, 2022, were you present at or around the area of Gratiot Avenue in Wilfred?
Yes.
Is that in the city of Detroit, County of Wayne?
Yes.
Okay, and on that day, were you in a vehicle?
Yes.
Okay, were you with an individual named Asian Madlock?
Yes.
Okay, and did you possess a firearm on that day?
Yes.
Okay, and at any point, did you point that firearm at any other individuals?
Yes.
Okay, and my understanding is that you believed that the individuals known as Charlemagne Hobbs and Tanisha Lindsay were a different person, correct?
Yes.
Okay, but you did point the gun at them.
Yes.
Were any shots fired towards them? Okay, people are satisfied, Your Honor.
Satisfied, Judge.
All right. Mr. Bloomers, rather, sorry.
Mr. Hearn, on or about the date of October 1st, 2022, were you at the location of 16820 Griggs Street? Yes. Is that in the city of Detroit, County of Wayne? Yes. And were you there with an Aaliyah Ingram? Yes. And while the two of you were there, was there a physical altercation? Yes. And during that altercation, did you put your hands around her neck? Yes. And did you put pressure on her neck, which caused her to struggle to breathe? Yes. Did you do that intentionally? Yes. Your Honor, the people are satisfied.
Satisfied, Judge.
All right, having complied with Court Rule 6.302.
Yes, Your Honor. Yes, Judge.
Yes.
All right, I find that Mr. Hearn's plea is understanding, voluntary, and accurate, and I'll accept his guilty pleas. He'll be referred to the probation department for a pre-sentence investigation report. It will set a sentencing date of March 10th.
I'm sorry, did you say that?
March 10th.
Oh, that's great.
Yeah,
All right, thank you.
thanks, Rick.
You too.
Case number 22-3674, 901-FH, information regarding this file can be found under case number 22-6748-01-FH. Calling case number 20-6775, 3936-01-FH. Information regarding this matter we found under case number 22-6748-01-F.
That's a black list. I know all of it. Yeah, for me. I'm going to.
Oh, no, what's going on?
You mean the rec, okay, good. Not like weird stuff in the water.
No.
The physical.
Yeah.
Not really. Not really.
You're like, you could just get it and then tell them swim around. Thank you.
Yeah, he wasn't. He wasn't in here today. Yeah, wasn't here. Totally back home. There's.
You're, Mr. Glenn is your prosecutor, right?
Correct.
Right. Did we call him? No.
I believe for the council text.
Oh, he did? Okay. Yeah, he was here early.
APM owner is Glenn on his way. He was here, so he'll.
We're ready at Bellinger? Yes.
Ready.
Wonder if it's what he should- Calling case number 22-4482-02-FC, People State of Michigan versus Sarah Bellinger. Appearances, please.
Andrew Molnar on behalf of the people, P 83773.
Good morning, Your Honor. May it please the Honorable Court, David Burgess, P 58557 on behalf of Sarah Bellin.
The man, please state your name. Morning, Ms. Bellinger, Mr. Burgess, and Mr. Molnar. Today's the date set for sentencing in this case. Mr. Burgess, have you had a chance to review the pre-sentence investigation report and sentencing guidelines, Ms. Bellinger?
Yes, Your Honor. It's factually accurate, no additions, corrections, or deletions. This was a misdemeanor, Judge, there.
Oh, you're right. Sorry about that.
As per the sentence, as per the PSI as well, there are no guidelines.
Right, of course.
That's okay. No, I understand normally cases in here. There are no additions, corrections, deletions. I would note to the court, Judge, that based on priors and stuff, she does appear to be 7411 eligible. Just based on, there's no recommendation for it, but she doesn't seem to be, she has no prior drug conviction. I don't know what the people's position is on that. It wasn't mentioned one way or the other in the PSI. So I just thought, because there's driver's license sanctions potentially in there with the drug cases, I just thought 7411 would be fair in circumstances. They list 4 prior, I think, one was driving a license, or allowing a licensed driver to drive, and one was MIP, and the other one was a assault.
Judge, I would just leave it to the court's discretion.
Okay. Ms. Bellinger, please raise your right hand. You solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God. Please state your name for the record and spell it. Did you read, write, and understand the English language? You had a chance to review the pre-sentence investigation report with Mr. Burgess, your attorney. Do you have any changes, additions, or deletions to the pre-sentence investigation report? Do you find it to be factually accurate? Okay. And Mr. Mulder, any issue with the pre-sentence investigation report?
No, Your Honor.
Anything you want to say, Mr. Mulder?
No, Your Honor.
So you're not objecting, is that right, to the 7411?
I mean, I believe she would be eligible, so I'll just leave it up to the court's discretion. Her only priors are a 2017 A and B that she pled guilty to. Yeah, let unlicensed minor to operate a vehicle. So she does appear to be eligible.
Judge, there was a sentence agreement in this case. Like I said, asked the court to follow it. I would note to the court, I don't think there was a requirement. She does have a tether on as a condition of bond. I just asked the court to obviously that condition is not part of the sentence.
Okay. And Ms. Bellinger, anything you want to say? All right, with that, it's a sentence of the court that Ms. Bellinger be placed on probation for 2 years under 7411, subject to the following special conditions. You must take medication as prescribed for you by a licensed physician. You must complete a psychological evaluation when you're referred by the field agent. You must complete mental health, domestic violence / pattern intervention or the recommended treatment following assessment by a qualified community-based service provider. You must waive confidentiality and allow any treatment program you're required to attend to disclose information to your field agent. You must obey all court orders. You must contact the supervising field agent no later than the first business day following your placement on probation or release from jail. You must submit to a search of your person and property, including but not limited to your vehicle, residence, and computer without need of a warrant. If the field agent has reasonable cause to believe the advisors violate the conditions of your probation. You must report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours, weekends and holidays accepted. You must not have verbal, written, electronic, or physical contact with Vincent Tuminello Jr., either directly or through another person. You must make genuine efforts to find and maintain legitimate employment of a minimum of 40 hours per week unless you're engaged in an alternative program approved by the field agent. You must provide ongoing verification of employment alternative program to the field agent. You shall not give reason to be terminated or voluntarily terminate your employment alternative program unless you first obtain written permission from the field agent. You're to pay $50 state costs and crime victims assessment, the amount of $75. You're to pay court costs in the amount of $650. The state court administrator's office has determined that $1,300 is the average cost to this court of the case that proceeds through it. And it covers salaries and benefits for court personnel, goods and services necessary for the operation of the court, necessary expenses for the operation and maintenance of court buildings and facilities. You may perform 50 hours of community service in lieu of court costs. You must not use or possess alcoholic beverages or other intoxicants. You must not enter bars or other places where the primary purpose is to serve alcoholic beverages for drinking at site, unless the field agent has first given you written permission for your employment in a specific location. You must comply with requirements of alcohol testing as directed by the field agent. You must not attempt to submit any fraudulent or adulterated samples for testing. You must not hinder, obstruct, tamper, or otherwise interfere with the testing procedures. You must present proper identification at the time of testing. You must not use or possess any controlled substances or drug paraphernalia unless prescribed to you by a licensed physician or be with anyone you know to possess these items. You must complete a substance abuse assessment when you're referred by the field agent. You must complete cognitive behavioral. You must complete the cognitive behavioral therapy program. You must not have verbal, written, electronic, or physical contact without the permission of the field agent with anyone you know to have a felony record. You must not have verbal, written, electronic, or physical contact with anyone you know to be engaged in any behavior that constitutes a violation of any criminal law of any unit of government. You must not have verbal, written, electronic, or physical contact with Leonard Smothers, either directly or through another person. You must not be within 500 feet of his residence, school, or place of employment. And you shall enroll in and successfully complete community, college, or vocational training approved by the field agent. In terms of rehabilitation goals, they are refraining from the use of alcohol, refraining from the use of illicit narcotics, obtaining additional education so you have more career opportunities, maintaining full-time employment so you can support yourself, and learning to engage in better decision making. Ms. Bellinger, it's my duty to advise you have the right to request leave to appeal from the Court of Appeals. If you're unable to afford an attorney to prepare post-conviction motions or perfect an appeal, this court will appoint an attorney for your public expense. It will provide that attorney with such portions of the transcript as that attorney may require to prepare post-conviction motions or perfect an appeal. You're further advised if you wish to file an appeal or motion, the request for the appointment of an attorney must be made in writing. File with the clerk of this court within 21 days of today's date. Ms. Bellinger, do you understand your appellate rights? Do you have any questions about your appellate rights? They've been placed on probation, and as such, you may be eligible for early discharge after you finish one half of your term of probation and if you've completed all required programming. If you complete all required programming, the probation department may notify the court of your eligibility for early discharge. The probation department does not notify the court of your eligibility for early discharge from probation and you not violated your probation in the previous 3 months, you may notify the court of your eligibility for early discharge. And I'm providing you with some additional information in writing regarding eligibility for early discharge from probation. So, Ms. Bellinger, I want to emphasize something. You've been placed on probation under 7411, which means if you complete all the terms and conditions of your probation and you don't violate, this will not appear on your record. Do you understand that? Okay. So my advice is if you're having difficulty complying, or if you're not sure what you're supposed to do, you know, if you have any questions, contact your field agent right away. Don't ignore it, because the last thing you want is to appear in front of me on a violation hearing and have this appear on your criminal history when you could completely avoid it. Okay? All right. Thank you. Good luck.
I mean, if you want to shoot it, I'll email it.
Yeah, she's up.
Right. So, you get it, you know, he doesn't- You're an idiot. Right, right, okay.
Yep, that's right. Just, yep, super. Yep, yep, yep.
There's two. What's that? Back here. Yeah, well, no, I'm here, ready to go. You guys ready?
Yes, Judge.
Calling case number 22-4819-01-FC, People State of Michigan versus William Dickerson. Appearances, please.
Good morning, Your Honor. Mike Glenn for the people. My P number is 77516.
Good morning, Your Honor. Michael Cobb, P78658. Here on behalf of Mr. William Dickerson. May it please most honorable court. Good morning. State your name for the record, Mr. Dickerson.
William Dickerson. Good morning, Mr. Dickerson, Mr. Cobb, and Mr. Glenn. Today's the date set for a pretrial.
Judge, I know that the last time we were in court, Mr. Cobb had inquired about some additional information that was, that he was seeking. And we're also waiting, I think, to see what was going to happen with the co-defendant who actually pled guilty in juvenile court. So she's no longer in the picture. I don't know whether she's been sentenced yet. I'm not sure. But it's my understanding that the co-defendant has pled. I do believe that there's some issues that defense wants to raise, and I think that we're going to have a bit of a discussion regarding that on the record.
Okay.
Judge, the issue that defense would like to raise, the defense supplied its discovery to the prosecution. It included, but wasn't limited to, an admission by a prosecution witness that someone else actually committed the crime. And so, Your Honor, the defense would, at the very least, like to file a motion and seek an evidentiary hearing to determine that witness's knowledge of the other defendant's commission of the crime, and I think it would speak to my client's culpability. I'd be looking to file a motion for the court. Additionally,
Isn't that why we had trials done?
yes, Your Honor. However, I believe that before we get to the trial, this could lead to more discovery that defense is entitled to prior to getting to a trial. Furthermore, defense also submitted to the prosecutor's office evidence that there may be co-conspirators who are not charged, who have knowledge of the whereabouts of the murder weapon in this case, between the parties in this case, and that may have also affected other witnesses' testimony, Your Honor. And so we believe investigation into these things could lead to exculpatory evidence, murder weapon, and other things. However, the prosecution has refused to seek out these co-conspirators despite having evidence, Your Honor. So I believe that a determination of whether or not we're entitled to knowledge of these co-conspirators is a matter that we should certainly handle before trial. Whereas they may have knowledge of facts pertaining to this case currently, specifically regarding the location of the murder weapon. And so we had bond hearings before this honor. I believe one of the main factors that the prosecution argued why my client shouldn't have bond was because they stated my client was responsible for them not having the murder weapon. And I believe we waited months in order to get a plea offer from the prosecutor because they were testing possible murder weapons. And so after spending months of the court time to test murder weapons, they now say the murder weapon doesn't matter. We don't need the co-conspirators who have knowledge of its location. And so, Your Honor.
Right, but so this is my question. If I were to conduct an evidentiary hearing, usually, right, it's a motion to suppress some evidence that's illegally obtained. It's a motion to quash if there's not sufficient probable cause to bind over. What sort of motion are you asking for, and what's the authority for any relief that you're requesting?
Your Honor, I'd have to take the time to actually write the motion, Your Honor. I believe the court would either grant or deny my motion after seeing it. Your Honor, I may have to get creative. However, I will.
Well, okay, but it has some legal
Correct,
authority.
Your Honor, correct, Your Honor.
Okay.
We don't have a trial date until January of.
I understand. Yeah, it's a ways off.
2024.
Right.
So I believe that there's ample time for defense to prepare a motion that would require, or not require, but it would urge the court to have the prosecution look further into this case where we have persons who would most likely be on probation to the state of Michigan, who have knowledge of things that we believe would prove my client's guilt. So
prove your client's guilt?
I mean, I'm sorry, prove my client's innocence.
Okay.
I apologize, but
I understand your
the murder weapon, Your Honor, can't be pushed up under the rug, Your Honor. So for the prosecution to spend months and months testing numerous weapons, and for that to be the holdup of the whole case for months and months, and then to say that the murder weapon doesn't matter when we have co-conspirators who have knowledge of its location, we believe that argument lacks merit.
All right. Well, I guess I'm not sure that I could force the prosecutor to do anything. I mean, I think if you can get an investigator. Are you retained or appointed?
I'm retained, Your Honor. And Your Honor, we've gone through thousands and thousands of pages of messages to find this information that we found. Our office resources have been exhausted. We're now asking the prosecutor to find guilty persons who they have knowledge of. We're just asking the police to do their job, Your Honor.
Well, I mean, I guess arguably, if there's evidence that they did do a thorough investigation, those are all issues that could be raised at a trial too. All right.
So Judge, just to make the record crystal clear, it's not that the people don't care where their murder weapon is, because we certainly do. But when it comes to the culpability of the defendant, I don't see the relevance of it. I mean, I've argued since the beginning of this case that there are dual theories of liability for Mr. Dickerson. Defense is well aware of that. In terms of the offers that have been made in this particular case, it came from the elected prosecutor, Kim Worthy. She's my boss. I can't go up to Ms. Worthy and say, hey, I need an offer now. Like, that's not how it works. And furthermore, we were waiting for testing from the state police because we wanted to see where the strength of our case was. So we're not going to negotiate against ourselves when we don't know the full case that we have. The evidence that defense is seeking, mind you, this is what was provided. It was a portion of the co-defendant's statement where she's on a cell phone talking to an unknown individual about many different things. And the defense believes that it's hiding a weapon. It may or may not be, but there are other statements that are made that are inadmissible. She's a co-defendant. So how is any of that coming out? So like the rules of evidence also have to be followed, not just like the case law that says whether you can have the evidentiary hearing or not. Whether the weapon is here, there, or anywhere, we don't know. Would we like to know? Of course. But I don't see the relevance of that and having to go through an evidentiary hearing for that. Now, what the defense really wants to do is get the main witness against Mr. Dickerson on the stand and cross-examine her about some statements that may have been made by the co-defendant. Once again, all of that is hearsay. And I think the court aptly pointed out that everything the defense wants to do can be done on cross-examination at trial. These are all questions of fact for the trier of fact. And I mean, I know the defense wants some of this information. Nothing stops the defense from doing it. And whether there are co-conspirators being investigated or not, it's still an active investigation. And that's something that the people don't have to disclose. And my duty is under Brady and Giglio for exculpatory evidence. And if I had it, I'd certainly provide it to defense counsel and for Mr. Dickerson, because I certainly don't want to go after an innocent man. Like that's not what we're here for. We're certainly here for the truth, and that's what we're gonna do.
Your Honor, we just asked for an opportunity.
Well, you can always follow the motion. I mean,
Thank you, Your Honor.
that's fine. And we certainly have plenty of time. And, you know, if and when it's filed, the court will do its diligence and examine it on the merits. And if an evidentiary hearing is required, we'll handle it.
Thank you, Your Honor.
All right. You want to set a next date, hearing date?
Your Honor, I'll set the date after I file the motion.
Okay.
We need to set the date now.
Well, I guess if it's going to be an evidentiary hearing, we're going to have people testify. I'd prefer to set aside specific time. If it's just a legal issue, you could do it on just about any day, preferably on a Friday.
So if defense counsel is gonna file the motion that I think he's gonna file, Judge, my response is gonna be, we don't even need the hearing. And so I'm not gonna subpoena witnesses for here unless the court orders me to do so.
Got it.
So unless I hear word from the court that this is what has to be done, like, I'm not gonna exercise any influence on these witnesses until the court thinks that we need to have the hearing.
Okay, well, why don't you file your motion, Mr. Cobb, and I think that's the hearing, the evidentiary hearing is necessary. We'll bring the parties together and we'll set it either through David or in person.
Thank you, Judge.
Thank you, Your Honor.
All right. Trial date, which is basically the next date in this case, right?
January the 15th,
No, our trial date is January
the 15th.
of, oh, I thought you said June.
No,
Yeah, January 15th.
January 15th.
I can't schedule it yet. It's too early.
Oh,
See, but it is January the 15th.
right, yeah, okay. All right,
Thank you.
Thank you, Judge.
have a nice weekend. Good morning, Mr. Shedrow.
Morning, Your Honor. I appreciate you letting me do this by Zoom, Your Honor.
Who do you have again?
Mr. Marco Carrasco,
Carrasco.
I'm sorry.
Okay. Is he here? Yes, please. Is this an address?
No. Was AR.
No, it's just not a, it's not a jazz. Okay, calling case number 23-000661-01-FH, People, State of Michigan versus Marco Carrasco. Appearances, please.
Judge, this case was added relatively late to the docket. I didn't see it when I pulled my docket yesterday.
Looks like it's
Is it-
arson, preparation to burn dwelling, FA.
And with the domestic violence
Oh.
counts at the end, it makes me think that it's likely a DV case.
He also has a second case up in March.
See what the prosecutor is.
Oh, Your Honor, if this is just an AOI, as long as bond being addressed is simply ordering a DSU report, I would feel comfortable standing in.
Okay, all right, let's do that then.
Okay. Andrew Molnar on behalf of the people, P 83773.
Mr. Shedrow?
George Shedro, in behalf of Mr. Marco Carrasco. For today's purposes, Your Honor, we waive reading, stand mute.
All right, and sir, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Please state your name for the record and spell it. All right. Do you read, write, and understand the English language? All right. You can put your hand down. If at some point you can't understand, if you don't understand or you can't hear something I'm saying, please interrupt and let me know. And then I'll stop and go over it again and make sure that you do hear and you do understand, okay? All right, if I ask you a question, you give me an answer, I'm going to assume that you understood the question, and the answer that you gave is the answer you intended to get. Fair enough? So you've heard and understood everything so far. Have you received written notice of the charges against you? Do you understand all the charges against you?
Yes.
And do you understand all the maximum penalties? All right, you're charged with count 1, arson, preparation to burn a dwelling, which carries a statutory maximum penalty of 10 years and or $15,000 fine, or 3 times the value of the property damaged or destroyed, whichever is greater. Do you understand that?
Yes.
You're also charged with count 2, felonious assault, which carries a statutory maximum penalty of 4 years and or fine of $2,000, DNA to be taken upon arrest. Do you understand that?
Yes, sir.
You understand you're charged in count 3 with felony firearm, which if convicted carries a mandatory 2 years in prison consecutive and preceding any other term of imprisonment, and mandatory forfeiture of the weapon, which means if you're convicted of that count, it's a mandatory 2 years you have to serve in prison, and that's, you have to serve that 2 years before any other time for a count for which you're convicted. Do you understand that? You understand you're charged in count 4 with assault or with felonious assault, which again carries a statutory maximum penalty of 4 years and or $2,000 fine. You understand that? And again, with respect to that count, you're charged with felony fire, which carries a statutory statutory mandatory 2 years in prison. Do you understand that?
Yes, sir.
You understand you're charged in count 6 with malicious destruction of personal property less than $200, which is a misdemeanor, carries up to 93 days in jail and or a fine of $500 or 3 times the amount of the destruction of the property or injury, whichever is greater. Do you understand that?
Yes, sir.
You understand you're also charged with count 7, malicious destruction of a building less than 200. Again, it's a 93-day misdemeanor. It also carries possible fine of $500 or 3 times the value, 3 times the amount of the destruction or injury of the property, whichever is greater. Do you understand that?
Yes, sir.
You understand you're also charged with domestic violence, which is a 93-day misdemeanor, and also carries a possible fine of $500. You understand that?
Yes, sir.
You understand that there's a third offense notice, which means for any felony that has a let's see, twice the maximum. So if it's any sentence could be doubled. Do you understand that? Vote your not guilty, please, on behalf of Mr. Carrasco. And we'll set some dates. Do you have any sense of whether or not this case is going to proceed to trial or not, Mr. Chandra?
Your Honor, we have another case, or your court has another case with my client on the 1st of March. And right now, all we're asking is that you put this case on that case so we can make a resolution on both cases.
All right, I'll set a calendar conference date then for March 1st, which will be this Wednesday.
Thank you, Your Honor.
I'm sure he can't hear you. You're talking too low.
I do also have some documents from, mental health illness. I don't know if I can give that to my attorney.
I would give that to your attorney, yes.
Okay.
Right? And we'll see you here on March 1st in person, okay?
And
All right, thank you.
Judge, I see that there is a $50,000 cash bond. Just for the record, is Mr. Carrasco on the tether?
Yes, I am.
Okay. All right.
What are the tether? Are there tether hours?
It's over.
There's no restrictions?
No, just where the frequent map. In the map.
I see
In the map.
do not go and it states that.
Do you work?
Tomorrow I'm going to Easter sales, I'm going for events right now. And also, I'm going to church.
All right, so I'm gonna I'll allow him out between 7 a.m. and 7 p.m. Otherwise, he has to be at home.
Thank you.
All right, we'll see you on March 1st.
Thank you, Your Honor. Mr. Carrasco, I'll talk to you later.
Thank you. Yeah, you got two
Bye-bye,
cases
Judge.
on. See you on Wednesday.
Thank you. Have a good weekend.
You can be out between 7 a.m. and 7 p.m. Right? Ms. Henry, who do you have?
I have Mario Johnson.
Are you ready?
I am.
That's
Yeah,
Mr. Bloomer's.
I'm gonna call you right back, 'cause I didn't
Oh,
get
it's
your
Mr.
name.
Bloomer's case.
I'll text him.
Carrasco case that you just called, it's the calendar conference for March 1st. Whatever.
choice. What do you want to take first?
Still looking for LePan. Did he zoom in?
He might be in the back. Is the pan in the back?
Don't matter, Wells.
Okay.
I know, just violated.
Calling case number 19-9331-01-FH, People State of Michigan versus Gary Wells. Appearances, please.
Good morning, Your Honor. Sean Callahan on behalf of the Probation Department.
Morning, Your Honor. Andrew Long, CP number 69568. Gary, state your full name. Say good morning to Judge Knapp.
All right. Good morning, Mr. Wells, Mr. Moxie, and Ms. Callahan. Go ahead, Ms. Callahan.
Your Honor, today's the date and time set for arraignment on a show cause warrant that alleges that Mr. Wells has not paid $75 per month towards costs and fees, and he has failed to resolve all outstanding warrants from 2021.
And that's true. He'll admit he didn't make the $75 a month payment. He thinks he cleared up some of these warrants, maybe not all. Also, the domestic violence out of Westland that's mentioned here in the second paragraph, he believes that was dismissed. But perhaps probation can give us some further details as to what exactly is outstanding. See a couple driving while license suspended here.
All right, sir, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Please state your name for the record and spell it.
Gary Wells, GARYWELLS.
All right, do you read, write, and understand the English language?
Yes, sir.
All right, put your hand down. You're going to be asked a series of questions. If at some point you can't hear, you don't understand something someone says, please interrupt and let us know. And then we'll stop and go over again, make sure that you do hear and you do understand, okay? And if you're asked a question and you give an answer, I'm going to assume that you understood the question, and the answer that you gave was the answer you intended to get. Fair enough? All right, have you heard and understood everything so far?
Yes, sir.
All right, how old are you, sir?
22.
And how far have you gone in school?
I graduated high school.
You're charged with violating the terms and conditions of your probation. You're on probation for carrying a concealed weapon and possession of a loaded firearm in or upon a vehicle, which carries a statutory maximum penalty of 5 years. Do you understand that?
Yes, sir.
Right. Under Michigan law, you have the right to a contested hearing. To challenge the probation department's claim that you violated your probation. At that hearing, the probation department would have to prove to me it was more likely than not that you violated your probation. Do you understand that?
Yes, sir.
And you want to give up your right to a contested hearing and instead plead guilty to the alleged probation violations.
Yes.
You want to plead guilty to the alleged probation violations. Has anyone threatened you, coerced you in any way, forced you to plead guilty? Has anyone promised you anything so you plead guilty? And is it true that you've not paid $70 per month towards your costs and fees?
Yes, sir.
And is it true that you've not cleared up all of your outstanding warrants in the district court?
Yes, sir.
All right, I'll accept the plea. Ms. Callahan, thoughts?
Your Honor, Mr. Wells is on probation to this court for HIDA. On February 14th, 2023, we were at the end of the 3-year mark. I would just ask that the court close this matter under HIDA and leave all costs and fines to a collection. He hasn't been involved in any new criminal activity. That's why I'm asking for the discharge under HIDA.
I think you have no objection, Mr.
No, sir.
All right, I'll close it under HIDA. You gotta get those other outstanding issues resolved. Otherwise, you know, you get dragged into district court, you know. At a moment's notice. All right, good luck. Have a nice weekend. next?
Next, we have Mr. Harris, Christian Harris.
Actually, can I take Mr. Boomer's case real fast? He's probably gonna be like 5 other places.
Yeah.
This is Mario Johnson we're taking right now. Calling case number 599 1-FH, People State of Michigan versus Mario Johnson. Appearances, please.
Good morning, Your Honor. Jacob Bloomers, P77307 on behalf of people.
Good morning, Your Honor. Kathy Henry appearing on behalf of Mario Johnson, P41314.
And is Mr. Johnson on Zoom? Okay, Mr.
Yes,
Johnson,
he
please
is.
raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Please state your name for the record and spell it.
Mario Johnson, MARIOJOHNSON.
All right. Did you read, write, and understand the English language?
Yes, sir.
You're handling this matter on Zoom today. Are you okay with handling this matter on Zoom?
Yes, sir.
All right, so it looks like we have a resolution. Mr. Bloomers, you want to place it on the record?
Yes, Your Honor. The plea agreement is as follows. Defendant will plead guilty to a reduced count 1. That would be an attempt assault, resist, obstruct police officer. That is a 1-year misdemeanor. People agreed to dismiss count 2. And the defendant would also plead to count 3, domestic violence, which is a 93 days. There's a sentence agreement, 1 year's probation, matters counseling, no contact with Christine Sexton, any other terms and conditions set by the court.
Is that a full and accurate understanding, Ms. Henry?
Yes, it is, Your Honor.
All right, Mr. Johnson?
Yes, sir.
You understand you're still under oath?
Yes, sir.
All right, you'll be asked a series of questions. If at some point you can't hear, you don't understand something someone says, please interrupt and let us know, and then we'll stop and go over it again to make sure that you do hear and you do understand, okay?
Yes, sir.
And if you're asked a question and you give an answer, I'm going to assume that you understood the question and the answer that you gave was the answer you intended to give. Fair enough?
Yes, sir.
Have you heard and understood everything so far?
Yes, sir.
All right, how old are you, sir?
26,
And how far did you go in school?
12th grade. I got a GED.
Okay, are you a United States citizen?
Yes, sir.
I have a form in front of me entitled Settlement Offer, Advice of Rights, Notice of Acceptance, and it contains the plea and sentence agreement that was just placed on the record. Have you seen that form before?
Yes, sir.
And did you review that form and its contents fully with your attorney, Ms. Henry?
Yes, sir.
Did she explain the plea and sentence agreement to you?
Yes, sir.
Did she answer all of your questions?
Yes, sir.
Did she explain to you the rights that you're giving up by pleading guilty?
Yes, sir.
And did you authorize her to sign that form on your behalf?
Yes, sir.
Anybody force you to do that?
No, sir.
And did anybody promise you anything other than what's contained in that form?
No, sir.
Do you understand what this plea faces statutory maximum penalty of 1 year in jail?
Yes, sir.
And you understand if you proceeded to trial and you were found guilty, you'd face a statutory maximum penalty of 2 years in prison.
Yes, sir.
And are you satisfied with Ms. Henry's representation of you?
Yes, sir.
You understand you have the right to a jury trial, which 12 impartial jurors would decide whether you're guilty or not guilty of any crime charged.
Yes, sir.
You understand you can give up your right to a jury trial and allow me to sit as the fact finder and determine whether you're guilty or not guilty of any crime charged.
Yes, sir.
You understand you have the right to be presumed innocent until proven guilty.
Yes, sir.
You understand you have the right to have the prosecutor prove your guilt beyond a reasonable doubt.
Yes, sir.
You understand you have the right to have witnesses against you appear at trial to testify.
Yes, sir.
You understand you have the right to question or cross-examine those witnesses through your attorney, Ms. Henry.
Yes, sir.
You understand you have the right to call your own witnesses to court.
Yes, sir.
You understand you have the right to have the court subpoena or summon witnesses on your behalf, requiring you to appear.
Yes, sir.
You understand you have the right to remain silent at a trial and you cannot be compelled to testify.
Yes, sir.
You understand you have the right to not have that silence used against you. So in other words, if you decided to proceed to trial and not testify, I would instruct the jury that they could not hold that silence against you.
Yes, sir.
You understand you have the right to testify on your own behalf if you so choose at a trial and tell your version of the facts.
Yes, sir.
You understand that by pleading guilty, you're giving up all the rights that we've just reviewed.
Yes, sir.
Other than the plea agreement and sentencing agreement that have been placed on the record, has anyone promised you anything so you plead guilty?
No, sir.
Has anyone threatened you, coerced you, in any way forced you to plead guilty?
No, sir.
You understand that if I accept your plea, you'll be giving up any claim that your plea was the result of a promise or a threat unless you tell me about it right now.
Yes, sir.
Are you pleading guilty voluntarily and of your own free will?
Yes, sir.
Currently on probation or parole?
I'm currently on probation, 6-month probation with Dearborn for OWI. I just got on probation January 11th or January 11th.
All right. And do you understand that I don't know anything about that case, but it's entirely possible that by pleading guilty in this case, that could constitute a violation of your probation in Dearborn and subject you to further consequences in the Dearborn court.
Yes, sir. But I had already told them that I had I had another case that I was dealing with out of Detroit. They knew about it.
All right. So you still want to proceed?
Yes, sir.
All right. Do you understand that by pleading guilty that you're giving up your right to appeal your guilty plea is right, and even though the Court of Appeals may grant you leave to appeal, it is by no means obligated to do so?
Yes, sir.
You understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes, sir.
Right, to Mr. Bloomers and Ms. Henry, are either of you aware of any promises, threats, or inducements other than those already disclosed on the record?
No, Your Honor.
No, Your Honor.
Okay, Mr. Bloomers, would you please create a factual basis?
Mr. Johnson, can you hear me clearly?
Yes, sir.
Okay, I'm gonna ask you a few questions. If you can't hear me, if my sound cuts out, just let me know, okay?
Yes, sir.
Mr. Johnson, on or about the date of May 31st, 2020, were you at the location of 20047 Indiana?
Yes, sir.
Is that in the city of Detroit, County of Wayne?
Yes, sir.
Was a Christine Sexton also present there?
Yes, sir.
Did the two of you have a child in common?
Yes, sir.
I should have let me rephrase. Did you have a child in common at that time?
Yes, sir.
Okay. Was there an altercation between the two of you?
Yes, sir.
During that altercation, did you push Ms. Sexton's head into a wall?
No, sir.
Did you push Ms. Sexton?
Yes, sir.
Did you do that without her consent?
Yes, sir.
Okay, and were the police called?
Yes, sir.
And when the police arrived, were you placed under arrest?
Yes, sir.
When the police were trying to put you into the back of the squad car, did you attempt to use your body weight to prevent them from putting you in the car?
Yes, sir.
Your Honor, the people are satisfied.
Satisfied, Your Honor.
I comply with Core Rule 6.302.
Yes, Your Honor.
Yes, Your Honor.
I find that Mr. Johnson's plea is understanding, voluntary, and accurate. I'll accept his guilty plea. He'll be, well, this is a misdemeanor. Do we want to set this?
I have no objection to immediate sentencing.
I have no objections, Your Honor.
Is there a complaining witness who wants to make an oral impact statement?
No, Your Honor.
Right. Anything you want to say, Mr. Bloomers?
Your Honor, the people would just ask that the court file the terms of the agreement.
All right, Ms. Henry, anything you want to say?
Yes, Your Honor, we'd ask the court to follow the terms. However, we just like one slight amendment, and that is they do have a child in common. I believe it's a no contact order that's at part of that. And we just would like the court just to indicate that, you know, that as long as there's an order in the family court allowing for parenting time, that the contact be limited to just that.
Yeah, Your Honor, I guess that it should be clear. This no contact, I don't, the people's expectation isn't that it interferes with any family court orders.
Okay.
But there should be no contact outside of that.
Other than that, we'd ask the court just to exercise leniency.
All right, and Mr. Johnson, is there anything you wish to say?
No, sir.
All right. With that, it's a sentence of the court that Mr. Johnson be placed on probation for 1 year, subject to the following special conditions. You're to successfully complete batterers counseling. You're not to have contact with Christine Sexton with the exception of any required exchange of children that you have in common with Ms. Sexton. There's to be no assaultive, abusive, threatening, or intimidating behavior. You're to pay $53 state costs, a crime victims assessment, the amount of $75. You're to pay a probation supervision fee of $30 per month without electronic monitoring, and $60 per month if electronic monitoring is necessary. You're to pay court costs in the amount of $650. The state court administrator's office has determined that $1,300 is the average cost of this court if a case proceeds through it. And it covers salaries and benefits for court personnel, goods and services necessary for the operation of the court, and necessary expenses for the operation and maintenance of court buildings and facilities. $650 is half of that amount, and you can perform 50 hours of community service in lieu of court costs. Ms. Henry, are you appointed or retained?
Appointed, Your Honor.
And how many hours have you put in this case?
I put in probably about 4 hours, 3-4 hours, if that.
And how many, I'm sorry, how long have you practiced criminal law?
32 years,
And if you retain, what would your hourly rate be?
$350.
Understanding Ms. Henry's education, training, and experience, level of effort she's put in this case, and even if I dramatically cut her hourly rate, $400 would still be a bargain. So I'm going to $400 in attorney's fees. All costs and fees are due at the time of sentencing unless otherwise indicated. Mr. Johnson, it's my duty to advise you of the right to request leave to appeal from the Court of Appeals. If you're unable to afford an attorney to prepare post-conviction motions or perfect an appeal, this court will appoint an attorney for you at public expense and will provide that attorney with such portions of the transcript as that attorney may require to prepare post-conviction motions or perfect an appeal. You're further advised if you wish to file an appeal or motion, the request for the appointment of an attorney must be made in writing and filed with the clerk of this court within 21 days of today's date. Mr. Johnson, do you understand your appellate rights?
Yes, sir.
Do you have any questions about your appellate rights?
Yeah, I got a question about far as you said the cost and fines and stuff is due to their sentencing.
Right.
And how much would that be again? The total?
Well, so there's $53 state costs, crime victims assessment of $75, court costs of $650. And again, the court costs, you can perform 50 hours of community service instead of paying the $650.
Okay. And okay.
Right. You can go to the cashier's office and work out a payment plan if you want.
Yeah, okay.
Right. In terms of rehabilitation goals, they are refraining from use of assaultive, abusive, and threatening behavior and compliance with the law. All right. Anything else, Ms. Henry or Mr. Bloomers?
Your Honor, pursuant to the plea agreement, the people move to dismiss count 2.
No objections.
All right. Thank you, everyone. Have a good weekend.
Thank you.
Have a good weekend. Thank you, Your Honor.
Who's the other one you have, Mr. Maxon?
Harris, Kristen Harris. And I called the phone number for that third guy.
Excuse me, Judge, is Mr. Moxie handling Trayvon Johnson today? That's kind of a restitution hearing. We adjourned it for receipts.
He's willing.
Yeah.
Okay.
And Miss Callahan, I haven't been able to locate Donovan LaPan. I called the phone number that's on the cover sheet, and the deputies checked. He's no longer in custody.
Yeah, there are some mental health issues with Mr. Lappin. I don't know if the judge wants to call the case before I'm going to be requesting a KPS.
Understood. I
All right,
just
well,
wanted you to know.
let's deal with the in-person here and get him completed before we deal with people arguing. Calling case number 19-9272-01-FH, People State of Michigan versus Christian Harris. Appearances, please.
Good morning, Your Honor. Sean Callahan on behalf of the Probation Department.
For your honor, Andrew Moxley, P number 69568. Mr. Harris, state your full name, say good morning to Judge Knapp.
Good morning, Your Honor. My name is Christian Harris.
Good morning, Mr. Harris, Mr. Moxie, and Ms. Callahan. Go ahead, Ms. Callahan.
Your Honor, today's the date and time set for arraignment on a show cause warrant that alleges Mr. Harris failed to make payments towards court costs and fees and that he failed to undergo a psychological evaluation.
And Judge, Mr. Harris, he'll admit to failing to make those payments. He did tell me he contacted an agency in Oakland County. He can tell you more about that, but he's at least completed the initial intake for that psychological evaluation.
Sir, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? All right. And sir, do you read, write, and understand English language?
Yes, Your Honor.
How old are you, sir?
21 years.
I'm sorry?
21 years old.
And how far have you gone in school? Graduated high school? In charge of violating the terms and conditions of your probation. You're on probation for fleeing and eluding in the 3rd degree, which carries a statutory maximum penalty of, is that 1 year?
I believe that's a 5-year max, Judge. It's the 3rd degree.
Oh, sorry. You understand that, Mr.? Okay. Under Michigan law, you have the right to a contested hearing. You can challenge the probation department's claim that you violated your probation. At that hearing, the probation department have to prove to me it was more likely than not that you violated your probation. Do you understand that? You want to give up your right to a contested hearing and instead plead guilty to the alleged probation violations. Has anyone threatened you, coerced you, in any way forced you to plead guilty? Has anyone promised you anything you plead guilty? Is it true that you failed to make regular payments towards your costs and fees?
Yes.
And is it true that you failed to undergo a psychological evaluation? I'll accept the plea. Ms. Callahan, any recommendation?
Your Honor, Mr. Harris is on probation to this court for under HIDA. He was sentenced February 13th, 2020. And again, we're at the end of the 3-year mark. I'm going to ask the court to close the matter under HIDA and leave the money that's owed to collections.
All right.
Special day here, Frank Murphy. I have no argument for that.
You leave a need Mr. Moxie here today. Well, we're always happy to have him. So, all right, I'll close this under HIDA. The money's still going to be owed, so I suggest that you pay it, so rather than have collections come after you. I'll close it under HIDA. Have a nice week. Want to call a Pam?
Sure.
Calling case number 22-5826-01-FH, case number 21-7306-01-FH. People of the state of Michigan versus Donovan LaPan. Appearances, please.
Good morning, Your Honor. Sean Callahan on behalf of the Probation Department.
Morning, Your Honor. Andrew Moxley, P number 69568.
And Mr. LaPan is not here.
No, Judge, I attempted to call the phone number that's listed, left a message, haven't received a call back. The deputies double checked the inmate roster. He doesn't appear to be in custody at this time.
And Ms. Callahan, is it fair to say he was provided with notice of this hearing?
Your Honor, he was. The Probation Department attempted to contact Mr. LaPan at his last 2 addresses, both on February 9th and on February 15th, and they were unable to locate him. I would ask this warrant be issued.
And I also called his name out in the hall, Judge, no response.
All right, I'll issue failure to appear warrants in order to remit.
Thank you.
Calling case number 21-7306-01-FH, information regarding this document under case number 22-5826-01-FH. Okay. Mr. Trayvon Johnson here. Okay. No Trayvon Johnson. Trayvon Johnson.
I'll just call his name out.
Calling case number 20-000215-01-FH, and case number 20-000216-01-FH, People of State of Michigan versus Trayvon Johnson. Appearances, please.
Sean Callahan on behalf of the probation department.
Morning, Your Honor. Andrew Moxie, P number 69568.
Mr. Johnson is not present. Go ahead, Ms. Callahan.
Your Honor, today's the date and time set for a restitution review. When we were last here, Mr. Johnson had a probation violation admitted to having broken the window of Miss Wanda Moore's home. Miss Moore is usually here. She contacted me this morning and said she was without power and couldn't attend on Zoom. She is disabled. She did provide documentation for the repair of the window to be $900. I'm not sure if the court would like to enter that amount now or adjourn it so that Mr. Johnson can be present when the restitution amount is ordered.
Well, I mean, I don't know why he's not here. He was given notice, right?
Yes, Judge, he was in court at the last hearing in person.
Okay, well, at this point, he's not here. Today's the date set for a hearing.
That's fine, Judge. I'll be at the building for a while. Your staff can contact me if he appears. I did call his name out in the hall. There was no response.
Right, I'm gonna issue failure to appear warrants in order to remand.
Thank you.
Thank you, Your Honor.
Calling case number 20-000216-01-FH, information regarding this document under the case number 20-000215-01-FH. Okay. Oh, she's on Zoom. Are you handling Lathan, Karan Lathan?
Yes, Judge.
Right. Who's this?
Yeah, I was gonna say that sounds.
I'm on Karan Lathan, Your Honor.
Right, well, I'm gonna call that right now.
Hold on, she's not seeing.
Calling case number 22-7288-01-FH, People State of Michigan versus Carone Lathan. Appearances, please.
Andrew Molnar on behalf of the people, P83773.
Good morning, may it please this honorable court, Katani Sharif, P71454, on behalf of Karan Latham, who is present in the court.
And Mr. Lathan, please state your name. Good morning, Mr. Lathan, Ms. Reed, and Mr. Molnar. We also have Mr. Al-Talay. Did I say that right?
Yes, sir.
Good morning, everyone. Today's the date set for a final conference. Where are we at, Ms. Reed?
Your Honor, Mr. Lathan has been working diligently to get me letters. He did have a bout of homelessness, so that delayed the process. I'd like to write a gun board letter. He doesn't automatically qualify because he had a previous case. However, I speak to him regularly. He's indicated that he has, is it one or two, Mr. Latham? And he's really working hard to get me a third, and then I'm going to write that gun board letter for him to mitigate.
I have one from home and one from my ceasefire program.
All right, so let's see. How old is this case?
It is from November of 2022.
It is an old case, Your Honor, but as aforementioned, my client did have a bout of homelessness. Now we're back on track. So I wanted him to have 3 letters because usually that helps in mitigation, but I can write the gun board letter with 2.
And Ms. Reed, I would also send an email to Mr. Bill Heafy.
I did. Remember we talked about that for diversion? I sent the email already. I haven't heard back from him.
Okay, let me talk about it.
My client is adamant that he does not want to go to trial, and I do believe this matter can resolve. It's not a big case.
Why don't we set up a trial date anyways, just in case? That way. If the plea offer isn't as defendant or defense counsel would hope, we're not delaying the trial very much.
I'm going to CC my brother counsel. I'm going to send Bill Heathy another email for diversion, and I'll CC my brother counsel.
Okay, thank you.
Lincoln. How about May 22nd?
May 22nd works, Judge. Again, I do not believe this matter will go.
Thank you, Judge.
How many prosecution witnesses?
I would say 2, Judge.
I'd say 3, Your Honor. Three, Your Honor.
Okay, how many days to try the case?
I would say 1.5.
Yeah, 1.5 to 2 at best. Your Honor, would you be inclined to give us another pretrial date in case this matter resolves so we can come in and settle it?
Yeah, absolutely. How about, you're gonna submit that gun board letter very soon, right, Ms. Reed?
That is correct.
So. Here's the 24th. Why don't we set it for about March 17th?
Okay, that works good.
Do you have anything on March 15th, Judge?
I think that'll be okay. That's fine.
Thank you. Hmm.
All right. We'll see you on March 15th.
Thank you, Your Honor.
Trial form to be signed too, which will be certified. Okay, have a nice weekend, everyone.
Thank you.